Now is a time of challenge for all of us. Clearly, as we can see with what's happening today on this program, this is also an immense opportunity for growth, both personally and professionally for everyone. NARI has been a resource and a community to so many. I absolutely love that we have people from other states here today, and I just think that's really a special thing. NARI's been a resource and a community locally and nationally, and a couple of ways that we've been coming together and providing value to our members is the Open Roundtable that so many people have been taking advantage of, and I'm really glad to see that people are finding value in that. We've also had a number of really great webinars, some great educational opportunities and ways to come together and ask questions and learn from each other. We've also been a great source of support for each other. I know in the roundtables that I'm normally a member of, we've learned a lot from each other in the last couple of months, and I'm incredibly grateful for that. I hope everyone else is finding value in their roundtables as well. On the national level, we've actually been able to get together nationally as well, even though we weren't able to do the spring meeting this year in person. Last week we met the delegates and we voted for the national officers and had the swearing in of the president and the president-elect. It was really a nice time to come together, even if it was not quite as much of a community as we would have hoped it could be. The national president also started a chapter president roundtable, which I find to be pretty valuable in that we're able to come together and learn from each other about what we're doing right now in order to help serve our members locally, and we're learning from each other in really nice ways. We've all had big plans for this year, and those plans have not gone as anticipated, and when things do not go as planned, it can be disappointing, but it also is an opportunity to make a new plan or reevaluate the old one. And as you do those things, I just want to remind you to lean on your NARI community and also consider giving back. So think about the ways that NARI has helped you now and think about how you might be able to help others, whether it be the association directly or your fellow members. You can help on a committee, both local and national. Most of you probably got the email that just went out today from national to actually serve on national committees. And we're also always looking for people to help out on our local committees. You can also apply for a board of directors seat. We're ramping up the board of directors selection for next year, and we hope to hear from you if you're interested. Lend a hand. Just lend a hand where you can, whether it's giving advice or being there for someone or borrowing someone some masks, whatever it is that you can do. Think about how you can be a really great asset to your community at this time. You are immensely valued as a NARI member. That's really the bottom line. You are valued. And I'm going to paraphrase a quote or a saying that I've heard many times, and that is that every person in the association, I'm going to paraphrase that part, every person in the association, everyone on this call is smarter and more experienced than you. And you are smarter and more experienced than every person on this call or in the association. And so we all have something to offer. We all have something that we can help someone learn from. So let's just connect and make sure that we're all making the best of the times that we have. With that, I will say a little note that our sponsors are the ones that make NARI events possible. Our event sponsor, ProSource Wholesale. Our event sponsor today is ProSource Wholesale. And thank you to our tabletop sponsors. We're going to take this opportunity to hear from our sponsors in some video footage.
I'm Chris Schmitz. I'm the Member Service Manager here at ProSource Wholesale. ProSource is a wholesaler for the industry trade, whether that's a designer, remodeler, builder, but basically we help them help their clients to create the memory spaces that they're looking to. The main thing that makes us really different is we're based off of relationships. Anybody can sell product, anybody can provide flooring or cabinets or those types of things. What we're really invested in is our trade pros, our designers, our remodelers, but also their clients, and making sure that they have the best customer experience ever, and also being able to buy the best products at the best price. People are going to use us because they want the largest selection in the metro and make sure that they're getting the best value for that quality product. A lot of designers will come in and use the showroom. I mean, it's a 14,000 square foot showroom with 40,000 products, and so they can pick the tile and they can pick the carpet and the hardwood and bring it all together for the whole home and work with their client in one location. Other people like to just send their clients into us and they work with the account manager. Our account managers know their products so well that they can make sure that they're getting those to the trade pro to be able to show you to create that space that you're looking for.
At Marvin, we make more than just windows and doors. We make brighter mornings, open invitations, and relaxing retreats. We make windows and doors inspired by how you live, so you're inspired to live well.
Hi, I'm Jackie with Water Doctors Water Treatment Company. Water Doctors is the industry leader that specializes in custom-built and engineered water conditioning systems. What differentiates Water Doctors is our commitment to the relationships we build with our clients and our industry trade partners. Our trade partners and clients appreciate knowing they will get the same great experience whether we meet on-site or if they prefer to come into our showroom to view our vast selection of products. Water Doctors employs a full staff of installation technicians, design engineers, service professionals, all ready to assist to continue to build and maintain a relationship for many years to come.
This is Kathy Fisher from Aspire Design Showroom Gallery. The uniqueness of Aspire is our relationships with contractors and designers, which ensures your experience has the perfect blend of urgency and physical focus, coupled with modern elegance of style. We know there's a timeline, we know there's a budget. At Aspire, we can proactively manage these, at the same time helping you select the perfect combination of products to create a tranquil space. At Aspire, we work obsessively so your dreams and reality meet. See you at our Plymouth showroom soon. Take care.
One of our dedicated local support teams will equip you with product expertise and compliance knowledge. We handle the details quickly and smoothly so you can focus on the big picture. With personalized on- and off-site support, our Pella partners can help cut time and hassle from every project so builders can complete jobs faster, get paid sooner, and reduce callbacks.
I'm Chris Jones, attorney with Helmuth & Johnson Law Firm. I'm so glad to be here today and have this opportunity to share some information about my firm. Helmuth & Johnson provides legal advice for contractors and others in the construction industry on a variety of topics, including contract review and drafting, liens and collections, project disputes, employment issues and representation, real estate issues, and other matters in this industry. We are a full-service law firm offering these and many more services. Helmuth & Johnson is a suburban firm with 45 attorneys and the resources to meet all of your needs in an efficient and cost-effective way. You can reach us at hjlawfirm.com. Thanks so much for your time today.
Thank you. What I would like to do is thank all of our sponsors. So again, we've got ProSource Wholesale, who is our event sponsor today, and our food sponsor is Aspire Design Showroom Gallery. Thanks, Aspire, for all the food. Let's see, and to our tabletop sponsors. So typically our tabletops are the kind of mini show or mini trade show that you see at our monthly meetings. And today we're not able to do that. So, but we still have some great sponsors. So let's thank our tabletop sponsors, Helmuth & Johnson, Marvin Windows, Pella, Water Doctors, Minneapolis St. Paul Magazine, who is our quarterly media sponsor. Next, let's congratulate all of our national CODI winners this year. So just to remind you all, we had 19 regional winners from the Minnesota chapter, and as of the CODI, the national CODI announcement a week ago, we have 6 winners of national awards from Minnesota. We happen to sweep the bathroom and landscaping categories. So let's move on to, let's see, Blue Stem Construction, residential bath, over 100,000. Love the tile. McDonald's Remodeling, residential bath, 25,000 to 50,000. Edgework Design Build, residential bath, under 25,000. Mom's Design Build, commercial specialty. Mom's Design Build, residential landscape design, outdoor living, over 250,000. Amazing. Mom's Design Build, again, with residential landscape design, outdoor living, 100,000 to 250,000. Congrats, national winners. Awesome. Great work. Let's talk about some upcoming events. We have our Firm Night, June 30th. Before we get into the list of events, let's talk about the fact that no one knows what's going to happen right now. And so we're moving forward as though we are having events, and we're also moving forward as though we might have to have them be virtual. Just keep, stay tuned, and we'll keep you posted on how all these things are going to shuffle out. Firm Night, June 30th at ProSource Wholesale in Bloomington. Chief Architects is doing a professional development seminar on May 21st. That's online. Barrier-Free Showers, a professional development seminar. The date is to be determined, but that is by Schluter Systems. We also have an open roundtable every Tuesday at 11:30 to 1. This is typically a monthly meeting, and we've moved it to a weekly meeting because of all the support we want to provide for each other and for our members during the crisis that we're in. July 21st, golf outing at Prestwick. August 3rd, St. Paul Saints game. September 15th, Firm Night, Modern Design Cabinetry in Cologne. And I also want to welcome our new members. We've got Carriage House Studio, Craft Design Build, Cosentino, The Tile Shop, Lewis Electrical Contractors and Consulting Services, Creative Endeavor, and Buchanan Kitchen Curators. And that's all we have for the announcements. Now to get to the program. Our panel moderator, Chris Jones, is a partner at Helmuth & Johnson Attorneys at Law. His practice areas include community associations, construction and lien law, construction defects and warranties, insurance coverage, litigation, and real estate law. Chris also is the chair of the Program and Education Committee and is a very involved member of the NARI community. Take it away, Chris.
Great. Thanks, Danella. And I want to echo the earlier comments. Thanks for everybody for participating in this. It looks like we've got a pretty good big group here, and I'm glad that you're able to take some time out to do this and go through all the kinks as we try to run through these kinds of things. And we've got 2 really good speakers on this topic, and I'm glad we were able to get both of them. One is Nicole Blissenbach from the Minnesota Department of Labor and Industry, and the other one is Bill Geschwind, who a lot of you probably know is one of our very involved members. So I think Nicole is going to be the first to speak. So I'll give you a little bit of information about Nicole so you can understand her position. Nicole is DLI's Assistant Commissioner for Enforcement and Compliance Strategies and Partnerships. In that role, she provides leadership and direction for DLI's enforcement and compliance strategies and develops strong partnerships with labor law enforcement agencies at the local, state, and federal levels. Nicole previously worked as an attorney at Education Minnesota for nearly 10 years. Prior to working for Education Minnesota, she worked as an attorney with the law firm of Miller, O'Brien, Cummins. Nicole is a Minnesota State Bar certified labor and employment law specialist, which means she knows what she's talking about. And she's a graduate of the University of Minnesota Morris and earned her law degree from the University of Minnesota And Bill and I both had the pleasure of watching her speak at a CLE in earlier this spring on this topic, and we had thought that between the two of them, this would be a good topic given the current circumstances and where the way the market is going. So Nicole, I'll pass it off to you, and you can start.
I'm going to start out the presentation today with an overview of the Wage Theft Prevention Act. And it basically goes through the ins and outs of that law that passed last legislative session. So I'm going to, first I actually want to give a little bit of background. So that a version of that law was introduced first in 2015 and again in 2017. And then in 2019 is when the bill passed through both the Senate and the House and the legislature, and then went on and the governor signed it. So it's been since that time, since essentially last summer, the Department of Labor and Industry has kind of been working on, one, issuing some guidance related to that law, and then two, really going out and meeting with lots of different employers, groups, associations, employees, kind of going over what that law does, what it doesn't do, and providing a little bit of an overview so people know what their rights and obligations under those new provisions really are. So I'm going to go over a number of things today. We'll talk about the effective dates, new employer responsibilities, kind of what the changes were for wages and commissions, the new retaliation provision, the effect on the responsible contractor law, enforcement authority by both the Department of Labor and Industry and the Attorney General's office, and one of the more talked about aspects of this law, which is the criminal component. So I will start with the effective dates. The law basically had two different effective dates. So the criminal provisions went into effect on August 1st of 2019, and everything else went into effect on July 1st of 2019. This created a little bit of a rush when, after the bill was signed into law, employers, as well as the Department of Labor and Industry, didn't have a lot of time to get everything together and get their procedures in place. So I do want to say that we felt you at the time. There was a lot of concern and anxiety, and we felt it too at the department. Just so everybody knows, I started at the department in mid-June. So I was there for about 15 days, and this became one of my primary responsibilities as I came on with the department. So it was quick, and I felt like I had about 15 presentations that I gave in that first month of employment. So talk a little bit about what the law did. One of the biggest components, and I think it probably is the component that got the most talked about, is a new requirement that employees at the start of employment receive what's referred to as an employee notice. That's what the law refers to it as. That employee notice has about, I think in the law, there are 9 items that are required to be provided in that initial employee notice that needs to be provided to an employee at the start of employment. So we'll go through what each of those are. The notice, and I'll refer to this as the initial employee notice, primarily to keep it separate and distinct from a change notice or a change notification. That is a different requirement that we'll talk about in a little bit. So this is the initial notice that needs to be provided to employees at the start of employment. So one of the things that needs to be provided is the employee's employment status, and whether or not that employee is exempt from minimum wage, overtime, and other state wage and hour laws, and on what basis. So what we're talking about here is if somebody is an exempt employee, so they're not subject to overtime law, or they're not subject to minimum wage law, the employee needs to be informed of that on that notice. And where you can look to determine if an employee is, exempt or non-exempt is in Minnesota Statute 177.23, and then there are two rules that also go with that, and those are listed there. It's been kind of interesting. We get a lot of questions where people, when they saw that they had to start providing this, started looking at whether or not they were properly classifying employees as exempt or non-exempt. And there were some people who I think realized in digging into it that they had been misclassifying employees as exempt after they looked at what actually needed to be met in order to classify them as non-exempt. So good practice for employers out there. Another thing that's required in that initial employee notice are the number of days in an employee's pay period and the regularly scheduled payday. And then the date that the employee will receive their first payment of wages earned. So usually that is pretty straightforward, all needs to be included on that notice. When people ask me when this notice needs to be provided to the employee, the law isn't incredibly clear on that. What it says is that it needs to be given at the start of employment. And what our guidance has been is, you have a lot of paperwork that needs to be provided to somebody when they start employment. It's probably best practice to just incorporate this notice into that initial employee paperwork. And as long as somebody's receiving this notice before they receive that first payment of wages, so that they know when they will be receiving that, that should be enough to comply with the law. And of course, we will consider, reasonable action on that. So the initial employee notice must also include the employee's rate or rates of pay, whether it's by the hour, shift, day, week, salary, piece, commission, that needs to be included. So one thing to highlight here is that this is the employee's rate or rates of pay. So more than one rate can be included in that notice. Let's say I'm an employee that does a number of different jobs, and each job that I do has a different rate of pay. Those different rates can all be included on the notice to cover all the bases. Similarly, if somebody has a differential, like if you are working in the evening and you have an evening or a weekend differential, you can include that on that initial notice, and that would cover rate or rates of pay. In addition, allowances, if any, that are claimed for meals and lodging, this is not expense reimbursement. This is if you are going to count meals and lodging against minimum wage. So if you have, it's not used often, but if you are wondering if that is what is applicable to you, you can look at the rules that are referenced here, chapter 5200.0060 or 0070. And those will tell you that that's what is meant by allowances on that initial employee notice. The employee notice must also provide the provision of paid time off, whether that's sick or vacation, how that is accrued and the terms for the use, a list of deductions that may be made from the employee's pay, the employer's legal name and operating name, the physical address of the employer's main office or principal place of business, as well as the mailing address if that's different, and the employer's telephone number. And in addition to those 9 items that are outlined in the law to be required in that initial notice, the notice must also ask the employee if they would like to receive the information in a language other than English. So if the employee does check a box and say, yes, I want this provided in Spanish, then the employer must provide the items that are required under the law in that initial notice in that language. There is, just to note, on the Department of Labor and Industry's website, we have an example notice. It's not required to be used, but it can be used, and it's on our website. That notice is translated into 13 different languages and can be used. It's there in both Word and PDF. So it could be used and even changed if an employer is interested in using that. All right, so then now that we've talked about what's required on the notice, let's talk about what you're supposed to do with the notice as an employer. Employers are required to keep a copy of the notice signed by each employee. And I should have mentioned that earlier. The notice does need to be signed. That signature can either be electronic or in writing with a good old-fashioned pen. And probably easier now to do it electronically, but that can be done either way. And then I mentioned this earlier, there is also a requirement in the law that any changes to the information required, so those 9 pieces of information that are required in the initial notice, if that changes, then the employer is required to provide another change notification or written changes, the changes in writing before the date the change takes effect. So typically those changes are going to be to rate or rates of pay, possibly vacation or paid time off accrual and use. Those are the ones we get the most questions and comments about. So that change notification can be provided either electronically or in paper form. And there is no signature requirement on that like there is the initial notice, but that does need to be provided. Okay, so there were some other changes. So we're moving on from the notice requirements now. There were a couple other changes that happened in the law with regard to earning statements. So what you see on your screen right now, I'm not going to go through this. This is what it was already required in the law for earning statements, what needed to be on an earning statement for an employee. So there are some additional things that need to be included in that earning statement now. The additional things include the employee's rate or rates of pay and the basis thereof. So we talked about that earlier. That's something that needs to be required on the notice and on the earning statement now. Allowances, again, that's not reimbursement. That is an allowance that is deducted, counted against minimum wage. The employer's telephone number and the physical address of the employer's main office or principal place of business, and the mailing address if different. So those were the additions to that earnings statement. There were also a few additions to an employer's record-keeping requirements. So the things that are listed on your screen right now are what were included in the law before the change. And I won't go through those, but there were some additional ones. So now, in addition to the prior record keeping, there needs to be also a record keeping of an employee's hours worked each day in each work week, including the paid at piece rate, the number of pieces completed at each piece rate as well. A list of personnel policies provided to an employee, including the date the policies were given to the employee and a brief description, and a copy of the notice that I mentioned earlier, plus any written changes to that notice that were provided. In addition to those items that need to be kept with records, the records must be available for inspection upon demand by the Department of Labor and Industry. And they have to be kept at a place where employees are working or kept in a manner that allows the employer to comply with the demand within 72 hours. If records maintained by the employer do not provide the sufficient information for us to determine if people were paid correctly or if not paid correctly, what the proper amount owed is, the Department of Labor and Industry can make a determination based on the available evidence that we have collected in the investigation process. So the law also made a clarification of wages and commissions and more importantly, I guess to employees when they are owed. So there was a change that where employers must pay all wages, including salary, earnings, and gratuities earned by an employee at least every 31 days, and all commissions earned at least once every 3 months on a regular payday. So what was added there was the commissions need to be paid every 3 months. Now that is when the commissions are earned. We get the question, well, when are they earned? And that's typically going to be set forth in an agreement with the employee as to when they are earned. So that's not clarified in the law, but typically that would be set forth in whatever commission agreement or the policy that sets up commissions. The wage theft law further clarified a statute 181.101, which prior to this change was oftentimes referred to as a timing statute. And what the clarification did here was it essentially turned it into a substantive right to the payment of those commissions and wages at the rate of pay that's set forth. So changed it a little bit from a timing statute to a substantive right. There was a retaliation provision added to the law. So there's a prohibition from retaliating against an employee for asserting rights under the Minnesota Fair Labor Standards Act, the Prevailing Wage Act, and also provisions of the Payment of Wages Act, which is Chapter 181. Also includes protection from retaliation if you have filed a complaint with the Department of Labor and Industry, or have informed an employer of your intent to file a complaint. And if an employer violates that provision, the retaliation provision, there is a penalty added for each violation. There's also an addition of three additional provisions, sorry about that, to the list of laws that contractors have to that they are in compliance with and have not violated during the last 3 years to be considered eligible to bid on public contracts. So they added the prohibited wage practices and retaliation statute, the payment of wages, the 181.10 provides the every 31 days, every 3 months for commissions, and then the criminal wage theft provisions, which I will talk about shortly. So there were also some changes to DLI's enforcement authority. So there were clarifications and penalty amounts were increased for repeated violations of record-keeping laws. Also, the now has enforcement authority and can enter and inspect places of employment without unreasonable delay, can apply for an inspection order and can interview non-management employees in private regarding an investigation. For failure to pay wages as required under 181.101, the commissioner now can order an employer to pay those wages or commissions owed, pay an amount equal to the wages or commission owed as liquidated damages, compensatory damages that have been incurred by the employee. There can be a cease and desist order in that, and pay a civil penalty for repeated or willful violations. And this also, there was always a provision to pay a penalty equal to the employee's average daily wages, but the cap on the number of days was also removed in the Wage Theft Prevention Act. So it's equal to 1/15 of the commissions earned wages for each day that the payment is not made, and also allows the commissioner to penalize an employer up to $5,000 for repeated failure to submit or deliver records, or repeated failure to keep and maintain records as required by the law. And then also it allows the commissioner to, when an order is issued to an employer, to provide that order to a licensing or regulatory authority of one or more state agencies, political subdivisions that the employer is subject, also to a public contracting authority that may have a contract with with the employer, and the employees whose interests are affected by the order. The law also gave the ability for the Minnesota Attorney General's Office to enforce Chapter 177, so the Fair Labor Standards Act, the Prevailing Wage Act, and the Payment of Wages Act under their authority statute in 8.31. And then the criminal aspect. So the law already had a misdemeanor for someone, for an employer who had hindered a commissioner in the performance of their duties. and it added the hindering or delaying in the performance of duties of additional provision in the law. So also a misdemeanor there. And then so criminal wage theft is defined as the following. So wage theft occurs employer with an intent to defraud, and then each of these items. So fails to pay all wages earned, directly or indirectly causes an employee to give a receipt for greater than what they were actually paid, demands or receives from an employee a rebate, or essentially gives somebody the money and then asks for some of it back, or makes it appear in any manner that was paid were greater than the wages that were actually paid. So that's the definition of wage theft. One thing I like to point out is how that provision defines employer and employee, and that is a very broad definition under criminal law. So an employer is any individual, partnership, association, corporation, business trust, or any person or group of persons acting directly or indirectly in the interest of an employer in relation to that employee. And an employee is any employed by an employer. So those are very broad definitions. And then depending on the size of the wage theft is what the fines and prison would be, depending on how much. And this really tracks the theft statute, so it just tracks that. So that is, here is our information at the Department of Labor and Industry. We have, like I said, a number of pieces of information for people to use and access on our website, including the draft notice, some FAQ related to the wage theft law. We also do a wage and hour bulletin, and you can sign up for that. And then if there are questions, I encourage people to reach out to our labor standards unit. They probably would welcome wage theft questions right now because we are being inundated with questions related to COVID-19. So please feel free to reach out, whether it's wage theft or COVID-19. Our labor standards unit can answer questions related to employees and what the rights and obligations are in the workplace. So that's it from me, and I will turn it back over to Chris, I believe.
Or Dan, you can pass it to Bill because he's next. I'll just introduce him and say thanks to Nicole for that. So stay tuned, Nicole. We'll probably have some questions. I don't see any yet, but I'm sure there will be, and I appreciate letting everybody know that maybe there's a different topic here than COVID-19, and maybe this is an opportunity for everybody who falls into these categories to be able to look at these things now in terms of spring cleaning and getting things ready, and then ask any questions that they may have. So thanks, Nicole, and we'll look forward to the questions at the end. And next I want to introduce Bill Geschwind. Most people who are NARI members probably know Bill, and I've seen him around at a number of different events. And a little bit of background on Bill. Bill is the founder of Minnesota Construction Law Services. He earned a BS at the University of Wisconsin-Madison and an MBA at the University of St. Thomas while working in sales and management for manufacturing distribution companies. Bill started a general equipment store and later bought a construction equipment rental franchise, but he didn't stop there. He's a real overachiever. Bill later graduated from the William Mitchell College of Law, passed the bar in 2010, and 2 years later he opened Minnesota Construction Law Services. Bill, as most people know, is a member of NARI. He's also a member of Housing First Minnesota, where he chairs the Regulatory Affairs Committee, the Association of Builders and Contractors, the Minnesota State Bar Association, and is chairman of the board of the Twin Cities North Chamber of Commerce. In 2014, Bill received the Silver Award for NARI Minnesota Associate of the Year. Bill provides continuing education courses for contractors and attorneys in the construction and business law for NARI, Housing First Minnesota, ABC, and the National Business Institute. Bill, thanks for being here, and I appreciate your time.
Thanks, Chris. Thanks for the opportunity to talk with everybody about the practical implications and application of the wage theft law. Nicole, I think you did a great job reviewing the contents of the law, and what I wanted to focus on a little bit is is take a look at some of the practical things that have come up since the law was introduced. A lot of this has kind of faded away in the sense of being a significantly and frequently talked about topic. I know we did a couple of continuing education programs. I think Chris did as well over at Helmuth & Johnson. There were a number of them around the state, and the new wage theft law was certainly a big component part of it. What we wanted to do today was add in, after Nicole went through and talked about the contents of the law, how this might actually be affecting you in your business and what kinds of things you should look for. The law certainly is going to impact the way that many of you are conducting your business with your employees. So let's touch just a little bit on the exempt versus non-exempt that Nicole talked about in the new employee notice. There is, and you can, anyone out there, you can Google the U.S. Department of Labor fact sheet. I think if you just Google fact sheet 17A, 17A is the federal summary of all of the different types of employment and the high-level criteria that you have to meet to become considered an exempt versus a non-exempt employee. And again, exempt means that you're exempt from the Fair Labor Standards Act, and the most important component there is that the Fair Labor Standards Act requires that minimum wage be paid and that overtime be paid to employees typically working over 40 hours a week. So only exempt employees can be paid on a salary basis. And Nicole mentioned that a lot of employers have learned as a part of the wage theft law that came out that just because you're paying somebody a salary does not necessarily mean that they should be paid a salary and that they should not be paid hourly. And the piece that's really important here is that if you have an employee who is non-exempt, an employee who is to be paid hourly, as Nicole talked about the employment records that you're required to keep, that means you're required to keep daily and weekly record of the number of hours that those people work for you. You're also required to pay them overtime for any hours that they worked over 40 hours. What that means for most of you is a couple of different things. First off, just because the job title you have has maybe the term supervisor or manager or something like that in it, does not necessarily mean that that person is exempt. It also doesn't really much matter if the employee's salary is, for the most part, a certain dollar amount. So it's important that you check and find out whether the positions that you have in your company and that are being paid salary actually do fit within the requirements for that particular type of a position. I've got one slide up here related to the administrative employees. And the key here is really numbers 2 and 3, the second and third bullet points. So the primary duty of an administrative employee in order to be considered exempt must be the performance of office or non-manual work related to management or general operations of the employer. And then the second one ties directly with that. They have to be able to exercise their own discretion and their own independent judgment with matters of significance. Now, what exactly does that mean? Typically, it means that they have the authority perhaps to hire and fire, or that they're they have the ability to influence the hiring and firing of employees. They generally have to have the ability to spend money or to commit the company to certain financial obligations. So typically, a receptionist, for example, most admin assistants, an AR manager, an AP manager, these kinds of positions are generally not going to fall within the exempt status. They're going to be non-exempt employees. The other piece that's important when you're thinking about the exempt, non-exempt scenario, and what I suspect is not an uncommon practice in the construction arena, is that we're a seasonal business, and so very busy during the construction season, much less busy during the slow season. It's not uncommon for employees to bank hours so that you're paying them the same 40 hours a week without paying them overtime. And if they happen to work 80 hours in this 2-week pay period, let's say they're working 90 hours in this 2-week pay period, but they're going to work 70 hours in the next 2-week pay period, you still have to pay the employee 10 hours of overtime for that pay period in which they worked over the amount of pay. And I mentioned 80 and looked at it as a 2-week pay period. The overtime is based on a 40-hour week. So if you have an employee that works 45 hours one week and 35 hours the next, and they're still getting paid for their 80 hours in that 2-week pay period, you're missing 5 hours of pay that should have been paid as overtime pay to that employee. This starts getting into the wage theft issue, because if you are purposefully and intentionally not paying the overtime to an employee who's entitled to the overtime, you've now technically committed a wage theft. So it's going to be real important for those of you who have staff that are considered salaried employees, that you have a really good understanding of the basis on which they are considered an exempt employee earning salary, or you're going to have to go back to them and start keeping track of hours, paying overtime, and paying much more attention to that. So, so just pay attention. If you have any questions, I know you can get in touch with the Federal Department of Labor, and they've got a phone number you can call, and you can describe the kind of a position you've got. They can give you guidance on whether that would fall within the non-exempt, exempt. I suspect the Department of Labor would be able to help you out with the same thing if you've got questions about your staff. So the next thing I want to talk a little bit about, we're going to spend a lot more time on this, because this, I think, is an issue that affects pretty much everybody out there in one way or another. And it really gets, in many ways, to the heart of the way that the industry has adjusted its labor pool to allow for some flexibility, for some scaling up and down. It reflects in some ways the way that many of the trade laborers provide labor in the construction industry. And it's this misclassification of an employee who is being classified as an independent contractor. So we'll start with a couple of basic things. Everybody should understand by now that all subcontractors in Minnesota, and a subcontractor is anybody who is hired to work for money for another contractor. So if an owner hires an electrician to do work on that owner's property, that electrician is not a subcontractor, that electrician is a contractor. But if any of you who are contractors hire that same electrician to work in that same owner's house, but you're doing it under a contract that the owner gave to you as the general contractor, now that electrician is a subcontractor. Now, if a trade is required to be licensed under any of the licensing specialties, they carry a builder's license, they're an electrician, they're a plumber, they're not required to be licensed. Those are the people that need to be registered at the Department of Labor. That's going to also include painters. It's going to include, let's say, sheetrock installers. It's going to include carpet layers. It's going to include a lot of installation individuals that are not required to be licensed themselves. So any of those people that you hire, any of you out there who are contractors that hire somebody to perform work for you, needs to be registered. They need to, with the Department of Labor, either with a license for their trade or with an IR number as their registration. The big key is that under the subcontractor law, if a subcontractor is not registered, the law presumes that they are an employee of the contractor that hired them. And of course, that opens up the door to work comp, to withholding of wages, withholding of taxes on the money that's paid to them, a variety of things. So you as a contractor need to be very careful and make certain that all of your subs are registered, and keep track, especially if you use them over and over again, year after year after year. That registration is something that expires. They need to renew the registration. Make sure that you are checking up at least annually to make sure their registration is still good. Many of you, I suspect, have gone through the Department of Labor's investigation looking into the status of the subcontractors that hired you. So you understand what this process, what the investigation that they do looks like, and your requirement to provide proof of the individual or the company's registration during the time that they were working on projects for you. There is it's a violation of the law for a contractor to hire an unregistered individual, although generally speaking, the monetary penalty that is assessed by the department at the end of the investigation is generally forgiven. Forgiven is probably the wrong word. The penalty is stayed for the first violation, meaning that the penalty exists, it's there, but you don't have an obligation to pay it. So long as you don't have any subsequent violations, hire any unregistered people after that first one. If you do and the department finds out about it, you're going to pay the penalty from the first violation that was assessed, as well as any penalties that are subsequent to that. Another piece that's important for everyone to understand, and we're going to get into this a little bit more here in a short while, is that even though the subcontractors are registered, during the time they're working for you, they still must meet the 9-factor test. And I'll go over the 9 factors here in a little bit, but they still have to meet the 9-factor test that's required of a corporation or an LLC, an entity. That prior to the new, I call it the new subcontractor law, the current subcontractor law that requires registration. Prior to that law, if the entity was a corporation or an LLC, there was a safe harbor, and there really wasn't a test to determine whether or not they were complying with the 9-factor test. Under the new law, even if the entity is set up, they are a corporation or they're an LLC, if they're not complying with the 9-factor test, they can be determined to be your employees. So we're going to cover that. The other thing is that those individuals, those subs that are working for you, must have their own liability insurance policy, and they have to have their own workers' compensation policy. Now, I know there's some disagreement and a little bit of confusion on the workers' comp policy for a subcontractor that doesn't have employees. Our recommendation to all of those individuals, as well as to those of you who are general contractors and don't have employees, is you still want to carry a workers' comp policy. You can choose a policy that doesn't cover any payroll. That will make the premium that you pay for that policy very, very small. The main thing that you're owning that policy for is in the event somebody does end up on your job site. Maybe it was a casual laborer that you brought in to help one day and they got hurt. Maybe it's somebody else who is one of your trade partner's employees or a trade partner themselves gets injured on your job site and they make a claim against your workers' compensation insurance. By having that policy, the workers' comp will provide the legal defense against those claims, which even if you're found not to be the employer, the defending that claim can run some pretty expensive money. So very much worth having one, and you should really be insistent on all of your subs having a policy. Some of you have probably found out that if you have subs that don't have their own work comp policy, even though they may be exempt from having their own money, their own payroll on that policy, your work comp carrier is almost always going to call the money that you paid to those people for the work they did payroll, and they're going to adjust your premium upward as an account of those subs not having their own work comp policy. Now, we're going to tie this back to the wage theft law, because the misclassification of a subcontractor or an employee as a subcontractor can now subject you to the penalties of the wage theft law. And we're going to take a look at one specific case that's ongoing. This case started prior to the COVID stuff. To the best of my knowledge, it's still ongoing. It hasn't been resolved, and I suspect, like many things related to civil law, it may be working its way through the process, but much more slowly. And that's the case of the state of Minnesota. I have versus Merritt Drywall. The state is actually pursuing the owner of Merritt Drywall. Some of you may be familiar with Merritt. They are a sheetrock installation company. They're headquartered, I believe, up in Annandale or Clear Lake. If you've gone up 94, you get up that way. Many of you may have seen their building right on the freeway on the right-hand side as you're headed north. In any case, there was an investigation that began in the way that they functioned. And I will say that if you look at the case, the complaint that's been filed is public information. Merit Drywall did a number of things that they should not have done. We'll touch on a little bit of that, but I think you're going to see some similarities in what they're being held to account for with the way that many of you may well work with certain subcontractors in your businesses. And this really has to do with the way that Merit interacted with their laborers on the job site. I will also say, just as an aside, before we get into the sort of some of the things that you're going to see and I think begin to recognize here, is that one of the questions that's sort of being asked in this case, and I think it's going to become a bigger issue as time goes on, is that Merit Drywall was typically hired as a subcontractor by other contractors, either large residential developers, commercial contractors, and Merit then hired their laborers, pretty much all of them, as independent contractors. And the issue, the concern that many of us have with this relationship is that part of what's been sort of talked about is that Merit Drywall benefited perhaps from hiring their laborers as independent contractors, but so did the contractor that hired Merit, so did the potential developer or building owner that hired the contractor that hired Merit. And so everybody in the chain benefited from this potentially alleged misclassification. And so should and could the other upstream contractors and owners, developers in the chain also be held to account for the manner in which Merit handled its labor force. So we'll begin by some of the things that, and we'll just kind of go through some of the things that are in the complaint. And I think some of this is going to start sounding probably familiar to a lot of you. The first is that companies have an obligation to provide their work comp carriers with the information that the work comp company needs to determine the proper premium for insurance. And as most of you are absolutely familiar with, you are telling your work comp carrier at the beginning of the year what your expectation is for payroll. They set your premium, your insurance premium based on that projection. And then at the end of the year, you're going to go through an audit where they're going to justify up the actual amount of payroll you paid and come up with the amount of total premium you should have paid. And you're going to have an additional premium at the end of the year that's required to have paid the full premium for the coverage for all of the employees you had throughout the year. Companies aren't required to report payroll information for their independent contractors. And so the position that the state is taking is that Merit Drywall took a number of steps to misrepresent the payroll in an elaborate scheme. And I pulled some of these words specifically out of the complaint so that you can understand how the state is looking at this a little bit, in an elaborate scheme to avoid paying work comp premiums. So during the audit, and those of you who have been through an audit have experienced this, Merit provided certificates of insurance to Federated, their work comp carrier, showing that their subs were covered under their own policies. So their subs had their own work comp policies. And the claim is that had Federated known that these employees, and they called them employees, not independent contractors, that these were employees being misclassified, a significant amount of additional premium would have been owed to Federated by Merit. They found that many, the state did, of those subcontractors didn't meet the 9-factor test. They weren't normal, what they considered to be normal functioning businesses. So here are the 9 factors, and some of you are aware of these. Some of you maybe have them in say, subcontract agreements, or some kind of an assertion, an affirmation you're asking your subs to make to you that they pass this 9-factor test. These are the 9 factors. They've got a separate business. They maintain their own either a federal identification number or social security number. They certainly can operate as individuals without having an LLC or a corporation, and they can run under their social security number. That's perfectly adequate, just so long as they're meeting all of these 9 factors. The sub has to control the means and the manner of the performance of the work and is contracted for the work. Now, there's a couple of pieces in here. What's important is that the sub controls this, but what's sort of unsaid here is that you have to be careful that you don't retain the right to control the means and manner of the performance of the work. It's a little bit of splitting hairs, but a true subcontractor is not being supervised by you or any of the employees of your company, has basically free reign to decide how they're going to deliver the end product of the work that you've hired them to do. The second component of this is that they have contracted for the work. That pretty much means that all of your subcontractors need to have a written subcontract agreement, and that they are operating under some sort of a bid for the work that they're doing for you. You're going to see in a minute how important this becomes. The sub is responsible for the main expenses related to the work. They're responsible for satisfactory completion of the work. That means if your sub messes up, makes a mistake, damages anything on the site while they're there, they're to be held responsible for correcting their work, for paying for somebody else to correct their work, for any of the costs of the damage that they cause. You're going to, again, see where this is going to come up here as we move along. Compensation has to be based on a per job or a competitive basis and no other. Now, you notice when Nicole was talking about the new employee notice that in the payroll part where you're disclosing how individuals are paid, one of the things that's listed in there is piece-based work. In other words, per square or per sheet of sheetrock. These are problems. These are not considered a per job or a competitive bid basis. Per job is I will sheetrock the house for you at a price of $5,500. Not a per sheet, not a per hour, no other basis. Or a competitive bid. Here's the job I have for you to do. Here's the price you said you'd do it for. The sub has to bear the risk of their own profit or loss for the work. That means if they bid the job and they lose money because it took them more money to get done, it took them longer than they thought it would be, that's their problem. They're going to lose money on the job. You don't have any obligation to make certain that they come out break even or make a profit on the job. The sub has their own continuing and recurring business liabilities. We're talking about things like cell phones, rent, vehicle expenses, anything that they might have that shows that they're actually operating a real business, the kind of expenses that most of you that have your own contracting businesses are familiar with and know that you pay every day. And then the sub's business success or failure depends on whether they're earning enough money in the work they do to cover the expenditures that they have to pay. Again, what several of these things are getting at is you can't pay by the hour, you can't pay by the square. Your subs have to bid the project and you have to pay based on that bid. So that's your 9-factor test. So let's take a look at a couple of the subcontractors and how things went with them that came out of this case. So subcontractor C1 was paid per sheet of drywall installed. They were not required to provide and were asked really no personal information before the work began. The work that they were doing was overseen and directed by a company employee. They were told when to take breaks. They were always paid in cash. I will tell you, when you look at the case, subcontractor C1, I think most everyone would look at as being a problem and being a kind of a subcontractor that isn't really a subcontractor, more of a day laborer, kind of person you've heard stories about, or picked up in the morning and hanging out in front of Home Depot and hired to work for the day and paid $150 cash. Real problem. I don't think there's any justification. I doubt that anybody would support this. Let's look at subcontractor C2. This one might sound a little bit more familiar to many of you who are looking to get laborers to work with your company. So we still had a person whose performance was overseen by a company employee at the job site. Remember, the subcontractor is supposed to be in control of the means and the manner in which they do their work. They should not be overseen and directed by a company employee on a job site in a very tight and supervised way. When subcontractor C2 came looking for work, the company explained to them that they don't hire employees, they only hire subcontractors. And in order to be a subcontractor, it was best if C2 had their own company and had set themselves up with insurances. C2 wasn't exactly sure how to go about doing that, so the company helped by setting up a company with the Secretary of State using a company name that C2 chose. The company paid the registration fee using the company's credit card. So it was not, they didn't give them the registration fee. This was a loan. It was told it was going to be a loan, and you'll see this comes up again. Now, what C2 also did, and this was to help make it easier for the company to communicate with C2, for C2 to communicate back with the company, they set them up with an email address on the company's domain. They're at company.com. And they provided them a portal into the company's construction management software that C2 could install onto their iPad. So they could keep track, C2 could keep track of the job assignments that were being provided to them and sort of the expectations that they had on those jobs. And it was made clear that the company Merit loaned the contractor money to cover the work comp premium that they were going to have to buy in order to get started, as well as their liability insurance. So this is not terribly uncommon with what many companies out there have done to help their sub laborers get set up with their own entity to be compliant independent contractors. The company instructed C2 to submit invoices for payments in the name of C2's company. The company paid all of those invoices with checks written to the company, and they made deductions on those for the loans that were provided for that work comp and for that registration with the Secretary of State. Over time, C2 had worked with them often enough. He was told at one point that if the company's supervisor wasn't on the job site, that it was C2's job to kind of be a supervisor and oversee the sheetrock installation that was being done on those sites. He was also told at times to instruct another one of the subcontractors that if they didn't perform a little bit better than they were currently performing, that underperforming sub was going to be terminated. So as part of the investigation, the state determined that the company regularly submitted competitive bids to general contractors in order to win projects based on the amount of money they were willing to do the work for. But they never solicited a competitive bid from any of their subcontractors. They didn't have any contracts, written contracts with their subs. They only had the subs sign an acknowledgement of their obligation to comply with the 9-factor requirements. The company frequently used the exact same trade subcontractors, the same laborers, for the work on their jobs. And when subs were injured on the job sites, they were told by the company that they couldn't file a work comp claim under the company's work comp policy because they weren't employees. The company's records showed that those subs were frequently paid either on an hourly basis or on a piecework basis. Federated uses that 9-factor test to determine the employment relationship, and they reported that because they were misled as to the status of those subcontractors over a period of, I believe it was a 3-year period that was being investigated, Federated would have realized premiums of over $309,000 higher than they were actually paid. Now, it doesn't necessarily mean that Merit Drywall pocketed another $309,000. It's entirely possible, and may turn out to be very probable, that the general contractor that hired Merit got a lower price for its sheetrock work than it otherwise would have, and maybe the owner of the project got a lower price than that person would have paid had these premiums been reported. So no one's making any suggestion that the company ended up with this extra premium money. What they are saying is that Federated didn't get their money, and that's what's going on here. So the company avoided paying the increased premium by misrepresenting the worker classification. The investigators then interviewed several other long-term subs, and they found that none of those subs were paid in a per-job contract. None of them bid their work. The materials were all provided for them outside of a few supplies that the individuals brought themselves. They were all paid either on an hourly basis or per square, per sheet of rock, some other form. Some of them used some of the company's tools. You got to be thinking things like, scaffolding, perhaps, maybe even reach forklifts, a variety of different pieces of equipment that a sub would ordinarily bring to the job site themselves. The company was providing some of those, probably bigger. One would imagine, it's not in the complaint. One could imagine that it might have been some of the larger, more expensive tools that the company provided that the individual trade laborers wouldn't have. When they made mistakes, when their work that they did had to be fixed, when they damaged things on job sites, they weren't required to repair that work. They weren't obligated to pay for the cost of that Merit might have incurred in having other people repair that work. And none of them really fully understood what it meant to be involved in an employer-employee relationship, or really a subcontractor relationship. They just wanted to work, they wanted to do their work, and they were willing to get themselves set up as independent contractors because that was the manner in which Merit would bring their laborers in, and that's what they had heard was something common in their industry to work on. So according to the state, the company engaged in an ongoing and elaborate swindle. This is out of the complaint. An ongoing elaborate swindle to misclassify employees, evaded many of the legal obligations that they had toward their employees, and materially misrepresented the employment relationship to Federated. And as a result, they felt that this was a major economic offense involving a high degree of sophistication and planning over a long period of time, involving a substantial monetary loss to Federated, which justifies the state asking for an upward departure from the normal sentencing guidelines. They're going after Merit pretty hard on this. And I think there are things that Merit should have and could have done better. But I think, for most of you looking at what was going on, this is not that uncommon for the way that our industry has operated for the past many, many years. There's a Minnesota rule out there that helps when Minnesota does an investigation into a misclassification claim. You'll see a lot of this is stuff that's somewhat familiar. I'm going to go through it real quickly here. We're getting close to the end of time, but if you have the right to discharge the subcontractor readily and without much of a penalty, it's probably not considered an independent contractor. Again, you can't be discharged from a job that you are contracted with for an owner. The argument is neither can a subcontractor be discharged from a job they're doing for you. Do they make their services available to other people? Are they compensated on a per job basis? We've talked about that. Are they in a position to realize a profit or loss? If the laborer has the right to leave anytime they want, basically at will, again, that appears to be much more of an employment relationship rather than them being obligated to perform the work they're going to do for you as it was contracted for. Did the laborer make any kind of an investment in their business? Are they responsible for things that they do on the job site? And here's a big one that many of you should be thinking about. Are the services they provide necessary to the fundamental business purpose for which you exist? Think about this. Many of you are contractors. Many of you are paper contractors, meaning that you sell jobs, you do some design work, but you really don't do any construction yourself. You don't have any employees that do. The question here is, can a construction company that has nobody in the organization perform work without, can a construction company that has no laborers that actually do construction have the laborers who actually do the work only be subcontractors, or is it logical that they would be employees? So pay attention to those. So again, we've got a few minutes left. I hope we've got enough time, and I'm certainly willing to stay for some questions if there are any. But if you have questions about the relationship that you've got, and they are different than sort of in the pre-wage theft era, I would encourage you to get in touch with your attorneys. Chris is certainly very up on this. I and the team here do a lot of work with this stuff. Many of you have other attorneys that you're working with. I would definitely take the time to ask the questions and look at the specific things you're doing and see how to bring your practices into compliance with the law. That'll be all I have, Chris. I'll roll it back to you.
Perfect. Thanks a lot, Bill, and I appreciate that. There's only one question, but I had a couple of maybe comments and thoughts, and I think the first one is it dovetails off what Bill was just talking about, but it's really for Nicole. Are you able to tell us, how many enforcement actions or what sort of activity there has been under this new wage theft law, just to give people an idea of how significant of an issue it might be, or what's maybe on the horizon after maybe we emerge through this pandemic?
Yeah, I can give a little insight into that. So we have not had any peer enforcement actions under the new provisions that were included in the law as part of the Wage Theft Prevention Act. And I say that, entirely under that. So if we have an investigation open into, let's say, a minimum wage violation or a failure to pay final wage investigation, we do now ask for the notices if it was an employee that should have received a notice. We ask the additional record keeping, we ask for that stuff. But we have not issued a penalty or a compliance order for a violation of the new provisions under the Wage Theft Act at this time. Our primary focus has been on education, been on getting people up to speed on what is required. So that's I guess that's a long and a short answer. Sure. We do. It will be those new requirements will be things that we ask for when we have an open investigation. Many of them get at some of the long-standing requirements of the law, right? So there is an obligation to pay people, there's an obligation to keep records, there's all of that. So it just kind of adds into that, those requirements long-standing. I did want to make one additional comment. I'm not sure if this will apply to people on the call, but when looking at whether or not an employee is exempt, I think it's important to emphasize that you do that calculation both under federal law and state law. There are differences that I know I'm trying to think in my head if there are any differences that would apply to the folks that are on this call, but and I know that here are two examples that definitely wouldn't, but like for instance, movie theater employees under federal law are exempt. Under state law, they are not. Agricultural employees, again, under federal law, they're exempt. Under state law, they're not. So it is important to note that it's always good when talking to your attorney to make sure that that analysis is being done under both state and federal law.
Okay. So the one takeaway from the start of that commentary was now's the time to really figure out how to get into compliance with this, since it's primarily just an education aspect now.
Yes.
Good. So we got a couple questions. I'll read the first one, and it's maybe more for Bill, and you can decide whether or not you think it's giving legal advice or if it's more of a broad generalization, but I'll read it to you and you can decide. We have 6 facility managers, 5 are exempt and 1 is non-exempt. They have the same responsibilities. What type of implications could we face not having them the same status?
Yeah, it's a good question, and I think I can do what us lawyers do really well and avoid giving legal advice by asking questions instead. Certainly the first question that comes up, because I think if they all have the same responsibilities, it would seem logical that they would all have the same classification. So it sort of suggests to me that either 5 are misclassified or 1 is misclassified. I can't really say from the question which one that might be, but I would say that this sort of looks to me like an employer who made a decision as to how they're going to pay people based on maybe experience or duration with the company. Maybe there's a promotion of one sort or another. And as many of us who remember the day that we got our first salaried job and we were no longer hourly, sort of took that as a sign of growing up into a real job. And perhaps this particular employer looks at moving people from an hourly to salary as being that, as opposed to whether they are truly exempt or non-exempt. So obviously the implications might very well be there really wouldn't be an implication if the non-exempt employee truly falls within the exempt classification. I don't think there's going to be a penalty there. The problem is if the 5 exempt employees are truly non-exempt, and it turns out that they've worked more than 40 hours in a work week, or some of the other, probably not a minimum wage issue. I'm guessing it would be more an overtime issue. You may very well have a bunch of unpaid overtime that those employees would be entitled to. I don't know, Nicole, do you have any thoughts on that?
Yeah, I think it's important to note that it's not the title of a position that matters. So if you have people who have the same title, you still need to go through the analysis, both of the duties of the position and of the amount the person is being paid to determine if they meet that the requirements to be classified as exempt. So titles are not what's important. It's the duties and the salary provided. That's what will trigger an exemption from the overtime clause.
Good, perfect. Okay, here's another question. This is the second question. This is the old sub of a sub question, which is always a good one. General subs out work to a subcontractor. What questions should a general contractor ask or enforce when a sub gives us a bid and then turns and subs that work out to somebody else without letting us know? How do you deal with that kind of situation, or what are some questions to ask or steps to take to deal with that type of situation?
I'll take a stab at this one. Nicole, correct me if you hear anything that doesn't seem quite right. I will tell you that in almost all the subcontractor agreements that we put together, I'm guessing that Chris does the same thing. We've got language in there that says that your subcontractors may not sub out the project without your authorization to do so. And that if they sub the contract out, that the subs have the same obligation to provide insurance and registration and the other information that you expect out of your subcontractor. Now, in the past, and I know that in the beginning of the new subcontractor law, sort of the question of registration was, we were all told that the duty to know what was going on only really went down one sub deep. It didn't go down into the subs. The Merritt case seems to be asking the question. We're beginning to get some more. I'm curious how the department might be looking at this. As I talked about when we were talking about the Merritt case, there's some concern that not only is the general that hires the sub responsible for our gaining benefit from that sub's work, everybody in the chain is realizing a benefit if the trade labor at the end of the string is somehow not being properly classified, not being properly compensated. Since everybody in the string is benefiting from the, if you will, the scheme, then everybody in the chain needs to be held accountable for knowing what was going on with everybody who's working on job sites. We've had a couple of investigations that we've dealt with where there are more questions being asked about who's supervising the job site, what person from your company is on the job site to know who's showing up and who's working. So we're beginning to see more interest paid as to whether you as the general running a site know who the people are that are on the site doing the work, who they work for, and what their employment status is. Nicole, what are you guys seeing and hearing there?
Yeah, I mean, I would agree with what you said. We're not going to, identify one rung and then stop there when we have an investigation. We're going to be asking people what they know, who's there, who's responsible for what, who are you reporting to? I mean, all of those questions that all of the factors that determine whether somebody is an employee or an independent contractor, we're going to be asking everybody those questions. So the investigations are not going to be narrow. And I think it's important to note also when we are doing investigations, whether it's one of our misclass investigators or one of our labor standards investigators, we're making an effort within the department to really streamline some of those investigations so that we're not, in the past, it's been very compartmentalized, right? You have a misclass violation, and then maybe the everything when it's done, said and done, gets packaged over and sent to labor standards for to see if there are, overtime violations or other wage and hour violations. And now what we're really focusing on is kind of streamlining that so that we're not having two different investigators do the same thing one after another. So that has been a focus, and really focusing on our investigations and how we start them out to, and this gets to our efforts with other enforcement agencies as well. So we have a working relationship with the U.S. Department of Labor so that if we have an overtime case, we can refer it to them because under, the U.S., the Fair Labor Standards Act, the Federal Fair Labor Standards Act, overtime is 40. Under the state law, it's 48 hours. So really building those enforcement relationships, and with the Attorney General's office, also the City of Minneapolis and the City of St. Paul, where we have new ordinances that can affect our wage and hour, the minimum wage ordinance, for instance, the sick and safe leave, really streamlining our regulatory efforts so that we're not having to repeat each other's work. It has been a focus. But let's say when we do have a misclassification case and we go through our steps, it doesn't always end there. So we will refer those cases once we are done to the Department of Revenue. I'm not always sure what they do with stuff after it goes there because it's a one-way, things go into the Department of Revenue, but we don't hear much information coming out because of data privacy laws. But we also refer those cases to DEED for unemployment insurance. And then I think it's also important to state that the Merit case is a work comp fraud case. So that case was primarily investigated by the Department of Commerce in their work comp fraud unit. So that's also, where you have wage theft, you're likely going to also have work comp fraud. So we see a lot of these areas kind of cross over each other. And I can just say that all of these different departments, all of these different agencies are working together to try to streamline our process.
I think the upshot is also then from a practical perspective for those attending is just you need to work to keep a tight ship, run a tight ship, so to speak. Checking in with your subs and asking questions and trying to get that information so you can stay on top of things that might come up. All right, I know we're running out of time. We were kind of over what we said. I got one other question here that I'll read, and maybe one of you can jump on it. And can you receive an estimate for work from a sub that states on the scope that will be paid on an hourly basis with their estimate of the hours they anticipate for completing that scope?
Doesn't sound good to me. It sounds to me like they're wanting to be paid by the hour. They're giving an estimate of the number of hours, which suggests to me, the way that the question was asked anyway, that if they work more hours, they're going to be expected to be paid more money. And perhaps if they work less hours, they're going to be paid less money. It sounds to me like it's an hourly arrangement.
Yeah, and I think that's sometimes you miss context in the question, but it might be more of a function of here's what I'm going to do, and here's how long I think, how many hours it would take me, and this is what it would cost. In which case, I would say, why don't you say I'm going to do this work and it's going to cost you $10,000, and and say it at that, and this complete that work. May be a better way to approach that.
Yeah,
Okay.
I would say having a beginning date and an ending date for the project is not unusual, but an estimate of the number of hours with a dollar amount certainly opens up. It certainly will make people who want to be suspicious. I'd avoid raising eyebrows.
Yep. So I got one follow-up question, which is something that we you touched on earlier, but we'll do this last question and then I'll wrap it up. Follow-up question is, on the one hand, we can't manage subs on site, and then in this case, it sounds like we have to know everyone from that company that is on site. It's sort of a question and a comment about, I think, Bill, you had mentioned earlier about not necessarily managing the subs per se, but then also understanding what's going on the site. Any comments, either from either you or Nicole?
Yeah, I would just say that we get that same question all the time. We're not allowed to supervise, but we have to supervise. And I'm going to duck out of this one. I'm curious to hear from the department's perspective how you square that circle.
Yeah, I think that when I say it out loud, I don't know if it will make sense or not, but I think there's a difference between supervision of work and knowledge of what's happening on a work site. Knowledge of who's coming on and off, what subcontractors are there that day, which ones are not. I think that that's a little different than actually directing work or supervising how somebody is doing a particular piece of work. To me, there's a difference, but I don't know. I'm happy if somebody disagrees with me too. Happy to hear that.
The only thing I would add, I guess, the way that I've maybe been able to duck the question or try to work the question is, for most of our contractors, they have carpentry skills and they're comfortable doing the carpentry work. When they hire a plumber, they don't look over the plumber's shoulder to instruct them on the manner in which they sweat solder a pipe. But they're more comfortable looking over the shoulder of a laborer who's doing framing or doing finished carpentry and offering suggestions for how to go about doing the function. So I think that the distinction is probably one that is more supervising and directing of the task versus are you accomplishing the objective that we had you there to accomplish. It is kind of it's a gray area, no doubt, but I suspect for the department, it's one of those kind of like, many of you have heard the old, I can't really define pornography, but I know it when I see it. I think this is one of those where the distinction between being a general contractor and knowing what's going on your job site versus supervising independent contractors who are there performing tasks is one that is clear in the example. It's just hard to describe in theory.
Agreed. That's a good summary. So I know I don't have any further questions. I know we're a little bit past time, so I want to honor everybody's time and just say thank you to both Nicole and to Bill for taking the time to participate in this. It was great information and some good discussion there, and something maybe different for everybody to learn about than things all COVID-19 all the time, which seems to be the gist of pretty much everything we're learning these days. So that's all I have. I want to thank the audience for attending too, and I know we had at least 50 or more attendees, which is really great, and I'm happy to see that. And everybody who attended will get a survey about this webinar, and to encourage you to answer the questions and give feedback so that we can continue to try to provide the various things and resources that we can. So Dan or Beatrice or Danelle, I don't know if there's anything else you need from me or anybody else. If not,
I think we're all set. We can go ahead and call it a day.
Perfect. Great. Thanks again, Bill and Nicole, and thank you everybody else for attending.
Thank you.
Everyone.
Bye.